We have seen a lot of white collar criminals who have fled our nation in order to evade their punishment under Indian laws. And in order to get them back and try them accordingly to the law of our country, our nation follows the extradition laws. Hello everyone, my name is Satyam Shivaach and I am an intern at LEXIS and Company. And in this video, we will discuss about the extradition law and procedure to perform extradition. Let's start off with what is extradition. In terms of Black's Law Dictionary, the official surrender of an alleged criminal by one state or nation to another having jurisdiction over the crime charged. The return of a fugitive from justice, regardless of consent, by the authorities where the fugitive is found. Extraditable person includes those charged with a crime but not yet tried, those tried and convicted who have escaped custody, and those convicted in absentia. The request distinguishes extradition from other measures, such as banishment, expulsion, and deportation, which also result in the forcible removal of undesirable person. International extradition is an obligation undertaken by a state in a good faith to promote and execute justice. The first act for extradition and asylum was adopted in 1833 by Belgium. Extradition Act not only specify extraditable crimes but also detail procedure and safeguard whilst defining the relationship between the act and the treaty. Now let's see what is the procedure of extradition under India. Extradition Act 1962. In India, the extradition of a fugitive from India to foreign country or vice versa is governed by the provision of the Indian Extradition Act. And right now our government has bilateral extradition treaties with 42 countries and extradition agreement with 9 more countries to quicken and ease the process of extradition. The basis of extradition could be a treaty between India and a foreign country, and in absence of a treaty or an agreement, an arrangement for extradition is made. Under Section 3 of the Act, a notification could be issued by the Government of India extending the provisions of the Act to the country or countries notified. The provision for extradition with nations with whom India does not have an extradition treaty is provided by Section 3, Clause 4 of the Indian Extradition Act 1962, which states that the central government may by notified order treat any convention to which India and a foreign state are parties as an extradition treaty made by India with the foreign state providing for extradition in respect of the offences specified in that convention. Moreover, India is also a party to 1997 International Convention of the Suppression of Terrorist Bombing. This also provides a legal basis for extradition in terror crimes. Our government on May 2011 ratified 2 UN conventions, the United Nations Convention Against Corruption and the United Nations Convention Against Transnational Organized Crime. In case of extradition treaty between the concerned countries, the extradition request has to be in terms of the specific requirement which is provided in it. In terms of the comprehensive guidelines for investigation abroad, an issue of letter rotatory issued by the Ministry of Home Affairs, extradition requests are made only after the filing of charge sheet, cognizance of the same and issuance of arrest warrant. If the accused is to be arrested and produced in the Court of India, the requisite action is through the extradition process. When the investigation filed the charge sheet and if the magistrate takes cognizance of the same, by issuing order, direction, justifying the committal of the accused to trial and seeking the presence of the accused to face trial, the request for extradition would be made to the Ministry of External Affairs. In passing such a warrant for the apprehension of the accused, the magistrate will be governed by the consideration indicates here above. Then the request in form of self-contained affidavit by the magistrate composing a prima facie case against the accused, and to compose a prima facie case, the affidavit is required to provide brief fact and the history of the concerned case, with everything like reference to the statement of witness and relevant documentary evidence required. Provisions of the law invoked and description of the accused establishing his identity. It is also necessary to specify the offences for which the accused is charged and the provisions of law indicating the maximum sentence thereof. The extradition requires made must contain an order of magistrate rationalize the accused person committal to trial on the basis of the evidence which were attached with the charge sheet, with direction seeking to secure the presence of the accused in court to stand trial in the said court from country to current stay, along with a copy of the first information report duly countersigned by the competent judicial authority. Moreover, the request must be sent with an original and open dated warrant of arrest stating clearly the offences for which the accused has been charged and the court has taken cognizance of the said section. Now let's see when extradition cannot be performed. An alleged offender may not be extradited to the requesting state in the absence of a treaty. The states are not obligated to extradite alien nationals or where the crime is not identified as an extraditable offense in the treaty. Extradition may be denied for purely military or political offenses. Terrorist offenses and violent crimes are excluded from the definition of political offenses for the purpose of extradition treaties. In case where dual criminality exists, where the conduct constituting the offense amount to a criminal offense in both the requesting country and the foreign country, the offense may be tried in either country, depending on factors such as territory where the offense was committed, as well as the nationality of the accused. Thank you.